All right. Okay. Welcome back to class. Uh, Sorry for the delay in getting this video to you. My kids had a snow day yesterday. So the time I had set aside to get this video to you and make the video, that kind of got disrupted. And today I had some family commitments earlier in the day. So the good news is I'm a fair person. If you have a good reason to have some short delays on getting assignments to me, I'll work with you. I understand that life happens, and I try to use good common sense about that sort of thing. But having said all that, I am sorry that there was a delay, and I hope that didn't mess up anybody's schedule too badly. Um, all right. So this week, we're just going through two chapters of your textbook. If you were to look at your syllabus and look at all the course objectives, there's basically two main categories. The purpose of this course is to acquaint you with ethical concepts that are relevant to healthcare, but also a lot of legal concepts and what I call quasi-legal concepts. Uh, so, for example, the American Medical Association, they have their own sets of laws, which we would call codes of ethics or ethical guidelines. They're not quite state laws, but they govern the profession itself. Um, we live in a litigious society. People get sued a lot. This is especially true in medicine. That can be good because it holds healthcare professionals accountable. It can be bad, but makes healthcare more expensive, causes a lot of stress for the healthcare professional herself. So yeah, there's an upside and downside to most things. All right, so this week we're going to be doing a little bit of each, getting you a little more acquainted with some legal terms and also looking at the ethical side as well. All right, so let me just pull up the reading questions, and we're just kind of walk through them together, and then I'll post a discussion board assignment where you can kind of carry this discussion further. All right, so we start off chapter 1, entitled An Introduction to Law and Ethics. All right, let's just jump in here. So go ahead and I don't need to read the whole thing. That's a little tedious, but just you probably have your questions in front of you. If you don't, pause this video and just kind of see what you wrote and compare it to uh, what I'm saying. Uh, if you got anything wrong, go ahead and correct that. You don't need to resubmit it. Remember, I'm grading you on reading questions just based on whether or not you gave it a good try. But as far as your own understanding and how this will lead into essays and tests, yeah, if you made a mistake, just stop a minute and correct it. Or if there's something you didn't think of that sounds like it's good to add, just put that in your own notes. It'll really help you out later. Okay, so page 4, we're in the section entitled Court Cases and Litigation, and we're just looking at the definitions of plaintiff, defendant, liable, precedent, and summary judgment. And you're probably kind of familiar with a lot of these already, so we can get through this pretty quickly. The plaintiff is the one who is kind of bringing a case, claiming they've been harmed in some way. This, of course, is in a court setting. The defendant is the person being charged with having harmed someone. They're either being asked to pay damages, as in a civil suit, or they're being threatened with some sort of jail type punishment or probation in a criminal context. A person is found liable, the defendant is found liable if it turns out they did actually harm the plaintiff. And again, in a civil case, this would usually result in some sort of financial compensation, and in a criminal case, going to jail, things of that nature. Okay, slightly more complicated and therefore maybe more interesting is the notion of a legal precedent. So it's not enough to have a law on the books. You have to know how to apply that law to actual cases. So if you bring a case to court, especially if it's a rather sophisticated case, what the judges and lawyers and eventually the jury will be forced to consider are other cases, prior cases, precedent cases that applied the same laws and rules to something similar. So, years ago now, there was this, the famous Roe v. Wade court case. So the right to abortion was grounded in a right to privacy. And the debate was not only about the Constitution, but it was how you apply various specific clauses in the Constitution to the issue of abortion itself. And in order to figure that out, part of what helps is looking at how the laws have been applied in the past. So those are legal precedents. Those are legal cases that have already been decided that involve many of the same principles and applications of law as the current case, and past decisions will guide future decisions. All right. Summary judgment. That's where the judge doesn't even really let the jury hear the case out and make a decision. The judge says something like, "Okay, this is a frivolous law case. There's not enough what is called legal standing to bring it. So maybe the person bringing the case isn't someone who was harmed by whatever happened, so they would lack legal standing." So every once in a while, a judge will just say, "Look, this case is over. It's dismissed." Well, now this happens all the time, actually. So that's called a summary judgment. All right. And then just to make sure your understanding was pretty clear, we looked at a specific court case on page 6. The plaintiff was Charles Reisel. He had an angioplasty, which is where you try to remove a blockage in the heart. I believe it involves small balloons and things like that being inflated. And he was suing Medtronic, who provided the device. The device malfunctioned. He was greatly harmed. But what's interesting was Medtronic was not found liable. The court ruled that companies who had gotten FDA approval for their devices, even if those devices failed, they weren't liable to pay damages. Okay, so that may strike you as surprising. That might even strike you as the incorrect or unethical result. The lesson here is eventually when you find your niche in healthcare and you're doing a certain sort of procedure a lot or a part of a team that's doing it, there may be some counterintuitive laws on the book governing what you're liable for and what you're not. And it's not always, the legal doesn't always match the ethical. This leads us to question 2. Read pages 8 and 9, comparing aspects of ethics and law. What is the definition of law provided by your textbook, and what is the definition of ethics? Now, to tell you the truth, I don't think that the textbook gives you a great definition of ethics. That's one of the reasons I gave you my own lecture on the nature of moral norms a couple of weeks ago, just so you can have a lot more clarity what ethics is about. But let's go through this. So the definition of law is pretty good. So it's a rule of conduct or action prescribed or formally recognized as binding, typically enforced by the controlling authority. So law is what you think it is. So think of a law against speeding. So the rule of conduct is do not go over, let's say, 75 miles per hour. This is formally prescribed. This is written into the law code. And if you violate it, this last part comes into play. The law will be enforced on you. You might have to pay a fine or do something else unpleasant. Okay. All right, moving right along. The definition of ethics I'm less thrilled with. Says standards of behavior developed as a result of one's concept of right and wrong. Well, that's a little simplistic. Just think back to our first lecture on ethics. But if you wrote that down, you got the right answer on these questions. But as we've discussed, ethical norms are geared toward figuring out how we can act in ways that are mutually acceptable to people in a society. And the most two big dimensions of that are we want to treat each other with respect and fairness. You can't have one group uh, gobbling up all the opportunities and goods and excluding other people, for example. Uh, People have to have, they have to share in the authority of decision making. So that's a fairness idea. And we also want to prevent each other from harming one another. So that's the heart of ethics. It's a set of principles, the goal of which is to allow us to live well with each other. And what I want to highlight here is that we tend to judge laws by whether or not they are ethical, not the other way around. So just because a practice is legal doesn't mean it's the morally right thing to do. And if a law is unethical, it'll often generate enough protest and social movement to get the law overturned. So, in a non medical context, obviously slavery was eventually overturned in this country. Women eventually earned the right to vote. And there were ethical arguments given about fairness and respect and the bad consequences to people who were negatively affected by those laws. And that's what got those laws overturned. And the same thing happens in healthcare context. If a law on the books turns out to be harmful or unfair, and of course many current laws are, then that gives a ground for ethical complaint against the law. And again, the purpose of ethics is to protect the well-being of people and to allow us to live together well. Okay, so that's number two. Moving on to question three, on pages 10 and 11, we're looking at a code of ethics and then ethical guidelines. So a code of ethics is just it's a set of principles intended to govern behavior. Here, it's the behavior of those caring for the sick. Um, so codes of ethics serve a similar function as a law. So, for example, the American Medical Association, they're charged with regulating the healthcare profession. You have to get accepted by them to practice. So if you're not a part of the American Medical Association, you can't really be a mainstream doctor in this country. So they certify practitioners. That's the word I'm looking for. And they use these codes of ethics and ethical codes of ethics. They enforce those upon those practicing medicine. So even though it's a code of ethics, because it's enforced, it's also having a kind of quasi-legal function. It's at least governing who can and cannot participate in a profession. Okay, ethical guidelines are the way the book sets this up. There's no sharp distinction here, but the way the book sets this up is the ethical guidelines are these more detailed manuals that take codes of ethics and apply them to specific scenarios and situations. So yeah, a good part of medical training now has this ethical dimension to it, where you run through case studies. You think about hypothetical or possibly actual scenarios if you're training in a live hospital setting, and you often will consult ethical guidelines. And they function a little bit like legal precedents in a way. Okay, well, how have these codes of ethics been applied before? how are they intended to be applied? Maybe that's a better way of phrasing it. And it's like a more filled in code because the application to real life cases is addressed. All right, one of the oldest codes is the Hippocratic Oath. Yeah, this is all pretty straightforward. That's all on page 11. When Hippocrates have allowed a doctor to assist a patient in committing suicide. Now, based on the wording, the answer is probably no. But if you look at the wording, I just want to point out an ambiguity. It says, I will give no deadly medicine to anyone if asked, nor suggest any such counsel. Now, the reason I say probable is the natural reading of the text is this has a universal scope. If anyone were to go to Hippocrates, hey, can I have some poison? I either want to end my own life early or poison someone else. The natural reading of the text is, Hippocrates wouldn't do that. But it's possible that he only meant to exclude the poisoning of others. That's possible. You'd have to know more about the historical context in order to nail that down for certain. And the reason I mention that here is because it kind of brings us back to this notion of a legal precedent, which also brings up issues and how do you interpret laws, how do you interpret codes. You often need a lot of context to do that well. Okay. I'll be interested to read what you wrote on. Oh yeah, so 3D also sounds like Hippocrates would have been pro-life, and in 3E, yeah, I'll be interested in what you wrote on that question. Why do you think Hippocrates was so concerned with the moral reputation of the physician, even outside of medical practice? Well, historically, I'll just give you something relevant to this. Years ago, Johns Hopkins Hospital ran a very unethical set of studies on the spread of syphilis and the population of Black Americans, where they would give patients syphilis and leave it untreated, even when penicillin became available. And it ruined the interactions between the trust between the medical care establishment and Black Americans for decades. So one answer is, the more ethical you are, the more trustworthy you are. So this is probably like a smaller picture question. Basically, if you're embedded in a local community, the more trustworthy you are in general, the more people are likely to trust you as a doctor. Of course, we do distinguish people's roles as physicians in their personal life. But yeah, there can potentially be some bleed over. And back in Hippocrates' culture, the bleed over was tremendous. If the person had a moral qualm with the doctor, the doctor might not be able to serve the community at all. We're a little bit more of a privacy-based culture, so it's not as intense, but it's just an interesting question to reflect on. All right, question 4 on the bottom of page 11, in the section bioethics. What is the definition of bioethics according to your textbook authors? Well, they basically say it's the discipline dealing with ethical implications of medical research. That's fine. Some people use the term that way. Clearly, the authors of the textbook do. But there's also a broader usage of that term where but the bioethicist deals with any medical issue that comes up within healthcare. So I have 2 anthologies of bioethics on my shelf, and they're not restricted. The articles in there are not restricted to research questions. So I guess we could just say there's a broad use of the term, which the textbook adopts, and there's also, no, which I think is the more common one, pretty much any healthcare issue in medicine. And then there's the more specific one your textbook authors have adopted, where it's focused mostly on medical research and what should guide that. The medical ethicist is a person who is trained this is question 4B, to apply ethical concepts specifically to the practice of medicine. Medical ethics is what is called an applied applied system of ethics. The goal is to go out into the real world, leave the realm of theory, and make decisions that are actually impacting people. So big hospitals like the Mayo Clinic, Phoenix Children's Center, often with a little more money, a little more resources, they'll often hire their own bioethicist to be part of their staff. Flagstaff Medical Center, for example, does not have a bioethicist. But a colleague, well, not quite a colleague, a friend of mine who's also a philosopher, who teaches at NAU, he actually has, he's trained in biomedical ethics. He actually has worked with the hospital on a lot of their trickier cases. Okay, now question 4C, what is an ethics committee and who typically serves on hospital ethics committees? Well, an ethics committee is what it sounds like. It's so let's say you're in a hospital. Let's say you have a tricky case. Let's say you have a patient who's completely comatose. There is no next of kin. So this person is just plugged into life support machines, and a decision has to be made. At what point do you shut those machines down, let nature take its course? Well, doctors aren't trained to make those decisions. They're just trained to deliver healthcare. But when to end a life under in a scenario like that, the doctor has no special expertise in. So you'd want to bring in other people. You'd want to bring in social workers. You'd want to bring in medical ethicists, the pastor, or a pastor often serves on those boards. So you get often members of the community can apply to serve on those boards. So the idea is to have a rich discussion of values, moral values as they apply to a case and make a decision. And that's what the ethics committee will do for tricky cases. Obviously, they don't address every decision made in the hospital or nothing would get done. But when a tricky case comes up, the medical team can ask for consultation with them. And certain sorts of cases, often they just have to go through the med ethics board. Like, for example, any kind of medical research being done in a hospital typically has to be approved by what is called an internal review board, which is basically a medical ethics committee. All right. All right, let's look at 5 and 6. So just take a second, read these, and then we're going to go over these 4 main principles. Okay, so it says the authors correctly note in the first paragraph of this section, Principles of Healthcare Ethics on page 33, that there are 4 principles that are universally accepted amongst healthcare professionals. That's right. And the 4 are autonomy, beneficence, non-maleficence, and justice. Okay. We talked a lot about autonomy last week. The value of autonomy in healthcare is empowering the patient to make his or her own decisions. But we only really want to do that when the patient is able to do that. So some of the subcomponents of autonomous actions, and this is question 5B, the biggest one is the patient has to be competent. They have to understand what's happening to them. They have to be able to comprehend the impacts of various treatments and have a sense of what's happening. So if a patient is, let's say they're undergoing a psychotic break, or if they have Parkinson's and their mental capacities are deteriorating, they might not be capable of being autonomous. Autonomy doesn't mean, here, you decide. It's more than that. It's you decide on the assumption that you can decide when. Okay, and a couple other dimensions of autonomy, you have to be able to act on your decision. So it's not enough to just say what you would like to see happen. Often that involves the cooperation of others. So you only really have autonomy if, for example, a medical care team will help you follow through. And yeah, you have to know the limits of your autonomy. So the third component, autonomy, is respect for others, or the autonomy of others. Okay, last week we talked about 5C, paternalism. This competes with autonomy. So in a paternalistic system, the medical care professionals, the doctors, primarily, they would make decisions for the patient, and that, as we saw last week, began to shift in the 70s. Okay, now let's define the next two and then talk about them. There's beneficence, which means the primary function of medical care is to heal and promote health in the patient, to limit pain. Actually, that's the next one. There's also non-maleficence, which is to prevent harm. Now, that could be damage to the body, or that could be more psychological, like preventing experiences of pain. And this makes good intuitive common sense. We go get medical help because we want to feel better, not worse, and we expect to be protected from harm from the medical establishment itself, not to be given bad advice, not to be given medications with unknown consequences. So that would fall under non-maleficence. 6C says, how are these two principles similar? How are they different? Well, they both concern consequences for patients. So beneficence says promote good consequences. Non-maleficence says do not harm, do not promote bad consequences for patients. Okay. And then, yeah, they're different because one has to do with the prevention of bad, the other one has to do with promotion of good consequences. But they tend to go hand in hand in a lot of ways. All right. Now, before we even look at justice, what's tricky about medical ethics is, and pretty much any ethical system, is it's often the case that more than one of these principles will be applicable to a situation, and it's not clear which one's more important than the other in that situation, or even how to apply it in the situation. So take non-maleficence, which is this idea of don't harm a patient. Now, let's say you have a patient with a terminal illness, and they're asking for assistance. Let's say they live in Oregon, in ending their life early, because in their mind, they want to avoid all the pain and suffering coming their way. So their view is, look, if you help me end my life, you're obeying non-maleficence. You're not harming me. You're preventing harm to me. But historically, there's a competing view, and at present, there's a competing view. Well, what can be more harmful to a patient than helping them end their life? Their life's over. Isn't death the ultimate harm? So you get debates about how to even apply that principle in a specific situation. Last week, we looked at clashes between autonomy and beneficence on your discussion board. So let's say you're a doctor, you have a patient, they don't want to accept a certain treatment, maybe due to a superstition or a phobia, but it would help them, and you could easily kind of like slip it into their system against their will. So that would be a clash between beneficence and autonomy. And of course, we would allow the patient to decide for better or for worse. So in our current context, autonomy would win out. But I just want you to see that these kind of clash, and it's not always clear how to apply them. And then the final one is justice. And the book does a decent job here. It says the just principle of justice is giving the patient their due. Okay. And justice issues, a good synonym for justice is fairness. To give a person what is due them is being fair to them. So that's a good way to think about the notion. So what do I want to? I mean, there's so much to say about justice. We're going to cover justice quite a bit. So it appears in anything from, let's say, access issues. So who should have access to what? Should that be determined by the government? Should healthcare be publicly funded at a decent minimum? Should that be a function of what people earn in their jobs, or if their job happens to provide quality insurance? Those are justice issues. Like, what sort of access to healthcare do we each deserve? What is fair? How do we divide up the healthcare resource pie? Other justice issues strongly overlap autonomy. Um, so take the notion of informed consent. So whenever a patient undergoes a procedure, they need to be made aware of all the possible likely side effects, benefits, and harms stemming from that procedure. On the one hand, this increases their autonomy. It empowers them to make a good decision for themselves. And on the other hand, it's fair to them. It's their health that is at stake. So we owe it to the patient to fully inform them. So that just shows how justice considerations and autonomy considerations, they're not airtight. They tend to interpenetrate. But we will organize a lot of our readings and a lot of our discussions around these four. You can call them values, you can call them principles. Uh, just by thinking, does the patient have autonomy? Am I benefiting or harming the patient? Is the patient getting what is due them, either in terms of information or access to care? Um, these are good lenses through which to raise ethical questions. So those four will carry through with us for quite a bit. All right, so that's enough for today. I'm going to post a discussion board, and that'll be due on Wednesday. And then early next week, you'll probably be finishing up the discussion board from last week. That's just how this class, or actually, early next week, you'll be doing the discussion board for this week that I'm about to post. All right, thank you, and see you soon.